Friends, living relationship. Living relationship is an arrangement whereby two people decide to live together on the long term or permanent basis in an emotionally and sexually intimate relationship. The term is most frequently applied to the couples who are not married. Living relationship concept is came where the both couples are not married, but they are consented to live each other. Yes, it is defined as a domestic cohabitation between an adult couple who are not married. Apparently, it appears like a stress-free companionship without any legal obligations. Most of the people nowadays feel that if there is a married life, then there are the certain obligations, certain responsibilities you have to bear with. But people think so that once you are in the living relationship, there are the certain less obligations, less responsibilities. It prima facie looks like, but actually it is not. Apparently, it appears like a stress-free companionship without any legal obligations. Conversely, it has many complications, responsibility, and legal liabilities. Recently, attempts have been made to bring it in the ambit of some laws. India and many guidelines pertaining to the maintenance, property, the legal status of a child has been issued in the various decisions of the apex case. In the one of the oldest judgment of the Badri Prasad versus Deputy Director of the Consulation in the year 1978, in which Honorable Supreme Court recognized the living relationship and found that once the person are living for more than 50 years together, it is presumed that they are in the living relationship, and relationship are the equivalent to the marriage relationship. According to the Supreme Court judgment in the Badri Prasad versus Deputy Director Consulation, living relationship in India are legal, but subject to covenants like age of marriage, consent, and soundness of the mind. There are the certain conditions. What are the conditions for the marriage? Suppose if it is age of the marriage is 18 years, and once you are in the living relationship, that you have to meet that criteria as well. That the girls should be at least 18 years of the age, and boys should be at least 21 years of the age. Question of the legality or legitimacy of the living relationship was relatively simple for the courts to settle, as fundamental freedoms are mostly elastic and courts have interpreted them broadly. However, several laws in the different aspects pertaining to living relationship continue to be too rigid for the courts to extend or interpret them for the benefit of the living partners. In the case of Khushbu versus Kanyam Mal and other in the year 2010, the Supreme Court opined that a man and a woman living together without marriage cannot be construed as an offense. Once the man and woman are living together, this is not an offense. In this judgment, the Honorable Supreme Court said so. Khushbu versus Kanni, Mal and other. When two people want to live together, what is offense? Does it amount to an offense? A special three-judge bench constituting the Chief Justice of the India, K.G. Balakrishnan and Justice Deepak Kumar Mishra, B.S. Chauhan observed. The Supreme Court said that there was no law prohibiting living relationship or premarital sex. Living together is a right to live. The Supreme Court said, apparently referring to Article 21 of the Constitution of India, which guarantees right to life and personal liberty as a fundamental right. The Supreme Court made the observations while reserving its judgment on a special petitions filed by a noted South Indian actress, Khushbu, seeking to quash 22 criminal cases filed against her after she allegedly endorsed premarital sex in the interview to various magazines in 2005. Right of the female in living relationship. We discussed what is the living relationship, and then we will discuss what is the rights available to the female in the living relationship. Female living partners have economic rights under protection of the Women and Domestic Violence Act 2005. There is a rights given to the woman in the living relationship that she can claim whatever the rights available to the wife under the Domestic Violence Act. Maharashtra government in the October 2010 approved a proposal suggesting that a woman involved in the living relationship for the reasonable period should, the word is inverted comma reasonable period. This is the required reasonable period. Maybe question of the interpretation, but at least there should be some reasonable period to live together. Then we are falling into the category of the living relationship. To get the status of the wife, whether a period is a reasonable period or not is determined by the fact and circumstances of the each case. National Commission for the Women recommended to the Ministry of the Women and Child Development in 30th June 2008 that the definition of the wife as described in Section 125 CRPC. Section 125 CRPC talks about the maintenance. Wife is entitled to the maintenance. Once the man or partner is not maintaining his wife, then every wife has a legal right to file and complain before the competent court under Section 2 or 225 CRPC to claim the maintenance. In the same manner, the person the ladies who are living in the relationship have the same right, equal right of the wife to file a application under Section 125 CRPC for the maintenance. Must include women involved in the living relationship. The aim of the recommendation was to harmonize the provision of the law dealing with the protection of the women from domestic violence and also to put in living couples relationship at par with that of the legally married couple. Whatever the rights available to the legally wedded wife, the same rights are also available to the ladies who are in the living relationship. There was a committee under Section 125 CRPC one I am talking about. There are the committees set up by the Supreme Court for this purpose called the Justice Malimat Committee in the year 2000, which observed that if a man and a woman are living together as husband and wife for a reasonable long period, the man shall be deemed to have married the woman. The Malimat Committee has also suggested that the word wife under CRPC be amended to include woman living with the man like his wife, so that even a woman having a living relationship with the man would also be entitled to alimony. 16th September 2009, the Supreme Court in the Avijit Vika Seth Auti versus State of Maharashtra and thus observed that it is not necessary for a woman to strictly establish the marriage to claim maintenance under section. In this judgment, the Honorable Supreme Court in the 16th September 2009 said so that it is not necessary for a woman to strictly establish the marriage to claim maintenance under Section 125 CRPC. A woman in living relationship may also claim maintenance under Section 125 CRPC. So all the rights which are available to the legally wedded wife, these rights are also available to the lady in the living relationship under Section 225 CRPC. Pal Katara versus Superintendent Nari Niketan, Kendra Bihar, Agra, and others. In the year 2001, the Allahabad High Court ruled that a lady of about 21 years of the age, being a major, has a right to live with a man even without getting married. If both so wish, if the lady wants to wish or with her consent wants to live with the man without wife, she can do so in this judgment. Honorable Court at Allahabad High Court. The Supreme Court observed that a man and woman, if involved in the living relationship for a long period, they will be treated as a married couple and their child would be considered as a legitimate child. Indra Sharma versus VKV Sharma in the year 2013. These all are the judgments I am referring to because I want to establish that yes, there is a living relationship, what are the rights available and what the point of view of the Honorable Supreme Court, High Court and different courts, taking into considerations of the rights of the person who are in the living relationship. The Apex Court hold that not all living relationships are in the nature of the marriage. The Apex Court referred to certain situations in which what would be the situations under which all those living couples residing in the living relationship, they can be treated and all the status goes to the wife, legally wedded wife. There are the certain conditions. Apex Court referred to certain situations in which the relationship between the aggrieved person referred to in Section 2A and the respondent referred to in Section 2Q of the Domestic Violence Act would or would not amount to a relationship in the nature of the marriage, would be opposite. In the judgment, the bench mentioned those categories which are only illustrative in the nature. These are only illustrative, that is not exhaustive. It includes domestic relationship between an unmarried adult woman and the unmarried adult male. There should be some domestic relationship between an unmarried adult woman and unmarried adult man. both are not legally wedded, both are unmarried. Relationship between an unmarried adult woman and unmarried adult men who lived or at any point of time lived together in a shared household. They should be sub in the shared household, like as a husband and wife, will fall under the definition of the section 2F of the Domestic Violence Act. And in case there is a many domestic violence, the same will fall under section 3 of the Domestic Violence Act, and aggrieved persons can always seek reliefs provided under chapter 4 of the Domestic Violence Act. Once there is a domestic violence with the partner in living relationship, then that lady can also claim whatever the rights available to the legally wedded wife under Domestic Violence Act. Domestic relationship between an unmarried woman and the married adult male situations may arise when an unmarried adult woman knowingly enters into the relationship with a married adult male. The question is whether such a relationship is a relationship in the nature of the marriage so as to fall within the definition of section 21 of the DV Act. Domestic relationship between a married adult woman and an unmarried adult male situations may also arise where an adult married woman knowingly enters into a relationship with an unmarried adult male. The question whether such a relationship would fall within the expression relationship in the nature of marriage. Domestic relationship between an unmarried woman unknowingly enters into a relationship with a married adult male. An unmarried woman unknowingly enters into a relationship with a married adult man may, in given situations, fall within the definitions of the 2F of the Domestic Violence Act, and such a relationship may be relationship in the nature of the marriage, so far the aggrieved person is concerned. There are the certain definitions is given in the Domestic Violence Act. Who is the aggrieved persons? Who is the woman? And what is the domestic relationship? And as per that definitions, once the person, even married, unmarried persons are married women, married men in the living relationship, they are fall into that category of definition of the Domestic Violence Act. Domestic relationship between the same-sex partners. Domestic Violence Act doesn't recognize such a relationship, and that relationship cannot be termed as a relationship in the nature of the marriage under the Act. If there are some partners who are of the same sex, the Domestic Violence Act doesn't recognize such a relationship. The rights are not available. Right to protection against domestic violence in living relationship. What are the rights to protect? There is no special legislation relating to the legal status of the living relationship in India. It is very clear that still there is no specific statute has been framed in which there is a living relationship has been established, the legal status of the living relationship. But there are the certain pronouncement of the judgments on the basis of which that have a legal status. There is no special legislation relating to the legal status of the living relationship in India. The Indian judiciary has developed jurisprudence over the years through numerous judgments. Supreme Court in Indra Sharma versus VKB Sharma held that women partners in the living relationship are protected in the Domestic Violence Act. We have already discussed. Section 2F of the Protection of Women from Domestic Violence Act states that domestic relationship means relationship between two persons who live or have at any point of the time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in the nature of the marriage, adoption, or family members living together as a joint family. These are the definitions of the domestic violence. Right to maintenance in the living relationship. We have already discussed the maintenance, even though in November 2000, Home Ministry appointed Malimat Committee, which was Committee of the Reforms of the Criminal Justice Systems. The committee submitted its report in 2003, where it made several recommendations in connection to the offences against women. One recommendation was to amend Section 125 of the Code of Criminal Procedure to alter the meaning of wife. As per the revision mode, the expression wife incorporates the ladies who were previously in a living relationship and now her accomplice has abandoned at his will, so a lady in living relationship can now get the status of a wife. It signifies that the female has been in a living relationship for a sensible period of the time. The time that is a very emphatically says that yes, there should be some reasonable time period to live together. Then it fall into the category of the living relationship. For a sensible period of the time, she sought to have the legitimate privileges as that of the spouse and can claim maintenance under Section 125 CC. It was noted that where partners live together as husband and wife, a presumption would arise in the favor of the wedlock. there is always a presumption once they are the living together as a husband and wife, it is presumed that they are a husband and wife, but legally they are not married. However, many have they opposed the same, as the section covers legally married women. As per law, Corpus Law General Report, a woman can seek compensation under Section 20, subsection 3 of the Protection of the Domestic Violence Act 2005 after demonstrating that a living relationship was in the nature of the marriage and was a domestic relationship. In the landmark case of the Chandmunia versus Birendra Kumar Singh Kushwaha and another in the year 2010, paragraph 42 of the said judgment says, we are of the opinion that the broad and expansive interpretation should be given to the term wife to include even those cases where a man and woman have been living together as a husband and wife for a reasonable long period of time, and strict proof of the marriage should not be preconditions for the maintenance under Section 125 CRPC. In this judgment, this is landmark judgment, it is included that the definition of the woman should not be interpreted only the legally wide open, but this should also cover the ladies who are in the living relationship to fulfill the true spirit and essence of the beneficial provision of the maintenance under Section 125. We also believe that such an interpretation should be just application of the principle instilled in the preamble of the Constitution, namely social justice and upholding the dignity of the individual. In case of D. Value Semi versus D. Chamal in the year 2010, it was observed that Supreme Court that a woman in the living relationship is not qualified for maintenance under Section 125 unless she fulfills certain parameters or conditions. Supreme Court further observed that couple spending weekends together or a one-night stand would not be amount to a considered a relationship in the nature of the marriage. In this judgment, Honorable Supreme Court has decided what should be the criteria for the living relationship. Once the person is spending a week time together, that doesn't mean they are in the living relationship and they cannot claim maintenance. A bench comprising Justice Markande Karju and T.S. Thakur said that to get a maintenance, a woman, if not married, has to fulfill the following 4 criteria. Conditions must satisfy for the maintenance under living relationship. First, the couple must hold themselves out to the society as being akin to the spouses. They must be of the legal age to the marry. There should be some legal age of marriage. There must be otherwise qualified to enter into the legal marriage, including being unmarried. They must have voluntarily cohabited and held themselves out to the world as being akin to the spouses for a significant period of the time. That what is very important. It is always being used. That is a significant period of the time. There should be some time period. In other Supreme Court cases, Madan Mohan Singh versus Rajanikanth in the year 2010, the court held that living relationship, if continued for a reasonable long period of the time, cannot be termed as a walk-in and walk-out relationship, and that there should be a presumption of the marriage between the parties living in such living relationship. By such approach of the court, it can be concluded that the court is in the favor of the creating a long-term living relationship as a marriage rather than giving or making it a new concept like as a living relationship. The landmark judgment case of the Champaben versus the state of Gujarat in the year 2012, the respondent and the petitioner started to living the relationship after the respondent promised to marry the petitioner. After some time, they had a baby, which the respondent refused to take care of. The petitioner sought maintenance of a child under Section 125 CRPC. The matter, after a couple of the appeals, went to High Court, and High Court gave judgment in the favor of the petitioner, stating that respondent is directed to pay the amount of the maintenance rupees 500 to the petitioner based on the order passed by the London magistrate and clear the areas of the maintenance within 2 months from that date. It is under the 125 CRPC. Right to sharehold house in the living relationship. Lalita Topo versus State of the Jharkhand and another in the year 2015. The apex court held that a living partner can seek maintenance under the provision of the Protection of Women from Domestic Violence Act. The bench comprises former Chief Justice Rajan Gogoi, Justice Uday Umesh Lalit, and Justice K.M. Joseph observed. In fact, under the provision of the Domestic Violence Act 2005, the victim, estranged wife or living partner would be entitled to more relief than what is contemplated under Section 125 of the Code of Criminal Procedure 1973, namely to a share household also. Legal status and rights of the children born in the living relationship. Then we will come. These all rights we have discussed about the wife in the living relationship. Now we will discuss what is the rights if there is a child born out of that living relationship. then what is the status of that child? Of course, it is a legitimate child. Then we will discuss. In the cases of SPS, Balu Subramaniam versus Suratan in the year 1993, the Supreme Court granted legal validity to the children born from the living relationship. In the recent case of the Katukandi, Italy Krishnan and other versus Katukandi, Ethyl Wilson and others in the year 2022 recently held that children born of the partners in the living relationship can be considered legitimate when the relationship is long-term and not walk-in or walk-out in the nature. Supreme Court guidance on the living relationship in India. Duration is more important. The relationship duration, share household, pooling resources and financial arrangements, domestic arrangements, sexual relationship, children, socializations in the public, intention and conduct of the parties. These all are there are the sources, and whatever the child being born from the death living relationship that have a legal right. And whatever he has the legal right, once they are married couple, whatever the rights vested with that child and couple in the living relationship, the same rights goes to that child, and they have also right in the ancestral property, as if they are the child born from the legitimate sexual relationship. Now, we have already discussed what is the living relationship and what are the rights available to the woman and what are the rights available to the children. If the children born out of this living relationship, then the child have the equal right, whatever the rights, to be a legally wedded couples. So whatever the ancestral right, the same rights goes to that boy in the living relationship, ancestral property, and whatever the property vested with the rights with the father, whatever the property owned by the father, that boy also have the same rights as the legally wedded couples have their rights. Now, the another part of this living relationship, once the couples are living together for 4 years, 5 years, 10 years, 15 years, and once there are the certain situations arises. Suppose I'm taking an example, because in the latest scenario, most of the couples that are preparing for the IS, IPS, judiciary, or other competitive exams, they want to live together, and probably they live together for 4, 5, 6, 7 years. Probably it may be 4, 5 years. And once there are the relationship or soul relationship, maybe the reason may be, suppose I'm taking an example, suppose boys and girls both are the law students and preparing for the judiciary exams. And once the boy has been selected as a judge, and later on some behavior changes, and unfortunately she has not selected to be a judge. And after appointing a judge, the boy's behavior has been changed, and he doesn't want to continue with her, to whom he was in the living relationship. There the situations are different. So our topic is also, once there is a failure in the living relationship, then what will happen? In the most of the cases, the girls file an FIR against their partner, boys, and allegations of the rape, that he has raped me for in the so-and-so years, and he is in the continue with me in the sexual relationship. So this is the bad part of the life. Once there is an FIR has been registered against any boys, then, and once you all are the learned friend being an advocate, how to protect the boys' rights, we will also discuss. Because once there is FIR has been registered against the boys, then most of the boys sometimes go behind the bar, and the entire life being ruined. Because once the FIR has been registered under section 376, immediately police arrest him, try to arrest him. And being an advocate, you are the learned friends. So how to protect the rights of that boy, we will also discuss with the case law, how to move the anticipatory bail, how to move the regular bail if it is arrested. So first of all, you have to think over that, once to save the life of the boy, once he approach you that yes, once we are in the living relationship and certain FIR has been registered against me under section 376 of the IPC. Please protect my life and move an anticipatory bail. Of course, you have to take immediate decisions and you have to move the anticipatory bail to protect that buyer to go behind the bar. So there are the certain judgments I would like to refer to, that is by the Honorable Supreme Court. Once you are go for the anticipatory bail, and in this is the same facts and circumstances that they are living together for some time of the period, and once their relation soars, then they filed an FIR. The Honorable, this is the High Court of Delhi in the Vikul Bakshi versus State of Delhi. The petitioner seeks anticipatory bail under section 438 CRPC, and once the boy is approaching you, and immediately you have to move an anticipatory bail without getting late, because once you will try to be late and do something and not take immediate action, then he may be arrested. Then it is our primary responsibility and duty, once client approaches you, immediately you should move an anticipatory bail. Petitioner seek anticipatory bail under section 438 CRPC in the matter of, if my learned friend wants to note the citation, otherwise it is also available on group, you can say YouTube, so you can look into that. First, try to understand. Bail under section 438, there are the anticipatory bail. Once you are moving an anticipatory bail, that has to be under section 438 CRPC. This is registered under PS Dabri status report and so and so. I have heard the learned counsel for the party, including the counsel for the complainant, and have examined the file. By an order that so and so, petitioner was granted interim bail protection and was directed to join the investigation as and when required. Once the anticipatory bail was moved, the learned, it has to be one. I would like to one thing more clarify, that once you are moving the anticipatory bail has to be before the learned session judge only. The Metropolitan Magistrate doesn't have a power to hear this anticipatory bail. Only the powers are vested with the either session court or in the High Court. But it is always advisable to approach to the session court first, because once you will approach to the High Court directly, then High Court may say that whatever the remedy available to you, first of all exhaust that remedy, then you should come to the High Court. So it is advisable that you should approach to the learned session judge first. Once the session judge bail has rejected, then you should go to the High Court. But in this case, learned session judge has granted interim protections immediate, and you should also always ask, once the session judge is not inclined to give the anticipatory bail, then you should ask for the interim protection. Interim protection means you should not be arrested. There should be no coercive action may be taken till the next date of hearing, or we are ready to join the investigations. No coercive action may be taken against me. This is the interim protection, and this interim protection was granted in this case, but later on, anticipatory bail was not granted, and by the session judge. Therefore, it has been dismissed. Then the applicant has approached to the Honorable High. Then the parties were acquainted with each other. The petitioner was granted interim protection and was directed to join the investigation as and when required. Undisputedly, the petitioner has joined the investigation since then. The parties were acquainted with each other before the incident. They are related to each other. Physical relationships took place between the two on the alleged promise to marriage. The prosecutors lodged FIR when allegedly the petitioner and his parents declined to solemnize their measure. There is a delay in the FIR. Considering the fact and circumstances, the petitioner is granted anticipatory bail, and in the event of his arrest, he will be released on the furnishing bail bond. So, once there is you have moved to anticipatory bail, then immediately you should move to the bail, and always sort that yes, there should be some interim protections or anticipatory bail. In another judgment by the Honorable Supreme Court of India, in the same fact and circumstances, what happened in this case? The interim protection has been granted. The petitioner is the accused, FIR no so and so. So an application for the anticipatory bail was filed before the learned ASD Katkaduma courts by order dated so and so. Interim protection was granted to the petitioner that he shall not be arrested. Subsequently, the learned special judge, North Delhi, East Delhi, had dismissed the anticipatory bail. Initially, the interim protection has been granted, but later on, that interim protection has not been converted into the anticipatory bail, and that anticipatory bail has dismissed by the session judge. Then the petitioner filed an application for the anticipatory bail before the High Court, which was rejected by the impeachment order. So that High Court petition has also been dismissed. There are remedy available for the anticipatory bail, and my learned friends, you should exhaust that remedy up to the Supreme Court. First of all, move the anticipatory bail to the session court. If and always try and hard press to take the interim protections once the anticipatory bail is not being granted at that particular time, because sometimes the session judge thinks that yes, there are the certain investigations going on and we are not inclined to grant anticipatory bail. Then you should hard press that no issue, my lord, unless and until you are not granting anticipatory bail, no issue, but grant me the interim protections, or no coercive action will be taken against me, and I am ready to join the investigation. Once you got the interim protections, that is sufficient. You can join the investigation. Later on, it may be converted into the anticipatory bail. Once it is not converted into the anticipatory bail, then immediately you should always be prepared, mentally prepared that yes, it may be dismissed by the session court. Immediately prepare and go to the High Court. And once the High Court is, and also insist there that yes, my lord, interim protection may be granted. Once the interim protection may not be granted, then it may be dismissed. Once it is dismissed, then you should immediately prepare and go to the Supreme Court. In the most of the cases nowadays, in such type of the scenario, the Honorable Supreme Court is granting bail. I will also discuss certain, because in the certain circumstances, you are discussing with the anticipatory bail, then you will discuss with the regular bail, and then you will discuss with the questioning. In the fact and circumstances of this case, of the cases which are in the sole living relationship, then petitioner filed an application anticipatory bail in the High Court, which are dismissed. Being agreed, the special leave petition has been filed before the Honorable Supreme Court, and the Honorable Supreme Court has granted bail. Sri Mukul Rohtgi and Senior Counsel referred to the WhatsApp message and all those things brought in records on so pages. We are satisfied that the petitioner has made out the prima facie case of the grant of anticipatory bail. If direct and immediate of the petitioner arrested, he shall be released under submitting the personal bail bond of 10,000. Then in this case, anticipatory bail was granted. And once your client is arrested, in these situations, what you will do? Of course, you cannot file anticipatory bail. Certainly, you will file a regular bail. Regular bail, of course, this is under section 3439 of the CRPC. You have to file the regular bail. Again, regular bail also will file before the Honorable Session Court, as well as to the High Court and then to the Supreme Court. Below the Session Court doesn't have a power to grant anticipatory bail. Sorry, the grant regular bail. Whatever the either may be regular bail, either may be the anticipatory bail. Regular bail or anticipatory bail under section, if there is a allegation and FIR has been registered under section 376, only and only the Session Court has a power to grant bail. Otherwise, High Court and Supreme Court. Latest judgment we are sharing with you, criminal miscellaneous bail applications 32824 up to 2020. This was decided in 2022. Latest judgment of the Honorable, it was decided in 16th February 2023. Recently, of 1 or 2 months earlier, 16th February 2023, this is decided by the Honorable Allahabad High Court, and in which what was the findings in this case, that the person who are living together are known to each other from so long period of the time, and there are some relationship or the sole relationship, and relationship has been broken, then the person is entitled for the bail. The apex court in the judgment of the Bharwada Bhogin Bhai Heritage Bhai versus State of Gujarat has categorically opined that in the current non-permissive Indian society, no girl would file a false case of the sexual assault against any person to avoid being maligned in the society. Much water. What is the wording being used by the Allahabad High Court? Kindly see the wordings, because in the current scenario, the earlier scenario in the like as 498A, that was being misused plenty of times. Then the Arnesh Kumar versus State of Bihar judgments came that without investigations, there should be no arrest, because in the once the initial 498A cases, most of the parents, Sas, Sasur, Nanad, Devrani, Bhaujai, all are being arrested immediately once the complaint has been filed. But nowadays scenario has been changed because this was being much more being misused. And in the same manner, the persons are living in the relationship for the 4, 5, 6, 7 years and imposing allegations that yes, he has committed the rape. It is not acceptable to at all. And most of the courts are granting anticipatory bail and regular bail. Therefore, this is the topic we had chosen to discuss, because most of the boys, young boys, hardly maybe the 20 to 25 years of the age, their entire life is being spoiled once he is go to the jail. So boys and girls should be very cautious about these things and all those provisions of the law. Much water, the word is being used, kindly see, much water has flowed down the Ganges since passing of the aforesaid judgment by the apex court. The Indian society has undergone a complete change during the said period of about 40 years, and now it is more often observed. Kindly see the wordings. Now it is more often observed that the false implication in the sexual offences is on the rise. What the wording is being used by the honorable courts. Now it is more often observed that the false implication in the sexual offences is on rise. The inordinate delay in the lodging the FIR is to be considered at the time of the adjudicating the bail. There is an inordinate delay once you are in the living relationship for the 4, 5, 6 years, and after the 4 years living together, having sexual relationship and intercourse, and you are lodging an FIR there in the case of the rape, is not acceptable at all, not digestible. Considering the fact and circumstances of the case, submissions made by learned counsel for the parties, the evidence on the record, taking into consideration the inordinate delay the lodging of the FIR by the informant, and also the fact that the trial is at the conclusive end without expressing any opinion on the merits of the case, the courts is to view the applicants have made out a case for bail, the bail applications are allowed. This is the judgment passed by the Honorable Court at Allahabad. This is the latest 2023 judgment. And we are trying to emphasis on the latest judgments so that my learned friend can understand what is the going on in the current scenario. This is another judgment we are referring to. Yes. This is the judgment of the Chhattisgarh High Court, Gokul Burma versus State of Chhattisgarh, 12th March 2018. It is also a regular bail. Present case is application under section 439 CRPC for a grant of the bail to the applicant. The application is in jail, registered police station so and so. The allegation against the present applicant as per the prosecution case is that the present application forcefully entered into the house of the prosecutor and committed rape way back in the year 2014. That the FIR has been registered in the year 2017, and whatever the incident takes place in 2014, almost after 3 years of the incident, the FIR has been registered. Then what is the finding of the court? That yes, having heard the contentions put forth on the either side and on perusal of the record, what reflects is that the present application and the prosecutors both are major persons, and all along there was a consensual relationship between the two, as there were sufficient opportunity and time for the prosecutors to have objected to the advancement made by the present applicant. But she willingly offered herself to the present applicant, shows the consensual relationship, and therefore this court is of the opinion that prima facie strong case for grant of the bail has been made out. Means after 4, 5 years you are lodging an FIR against the persons and you didn't raise your objections in the year when it has been happened, then it is a very fit case to grant of bail. And thereafter, the latest judgments you will also cite. This is the questioning of the FIR. In the most of the cases, the courts are very heavily to question the FIR under section 376 in the recent past. In the once their offense is committed under section 354, 376, most of the courts never go for the questioning of the FIR, but in the current scenario, most of the courts go and question the FIR. We will discuss this with latest judgments. This is the very latest judgment we are referring to probably this year. Yes. Dated on 28th day of February 2023. This judgment of recent this year, 28th February 2023, and this was the judgment of the Honorable High Court of the Karnataka at Bangalore. Justice so-and-so and party's name is here. What are the allegations? Once you will go into the allegations, what are the allegations? Kindly see. The learned counsel appearing for the petitioner would contend with vehemence that it is not one or two, but for the 5 years, the petitioner and respondent number 2 complainant were in love. From the last 5 years, they were together, wanted to get married, but in the view of the cost equations and not married, the marriage could not take place despite hectic reports on the part of the petitioner. It is then complainant turns around and brands the relationship of the petitioner with the second respondent to be on the false pretext of the marriage and alleges that the petitioner has sexual intercourse on several occasions on that pretext, and therefore the amounts to the rape. He would contend that it would not amount to rape by any stage of imagination, as it was the consensual. Further, this is the submissions, but what is the findings? I have findings of the Honorable Court. I have given my anxious consideration to the submissions made by the respective learned counsels and have perused the material on record. This is the finding of the court. The above narrated facts are not in dispute. The complainant was of the friend of another, who was the friend of the petitioner, which of the link of the complainant befriending the petitioner, relationship between the petitioner and the second respondent grew with friendship, metamorphosed into the relationship and paved way to have a sexual relationship. It went on for the several years. This is the importance. It went on for several years. This is a matter of record, as the complainant herself in the complaint register so narrates the entire story of the history of the relationship between the petitioner and the complainant. Since the entire issue now is spring from registration of the complaint, it becomes germane to notice the complaint itself. Complaint so registered against the petitioner on 10th of March 2021. Relationship was go for the 4, 5, 6 years earlier. Means the relationship started in the year 2016. And the complaint has been filed in 2021, of course, for 5 years. So now what is the findings of the court is the narration in the complaint and the statement under section 164 CRPC, if read in juxtapositions, what would unmistakably emerge is the petitioner and the complainant were in love and have had intercourse on the several occasions for years. The statement clearly records that the petitioner had made hectic reports to get married to the complainant. The family of both the petitioner and the complainant were known to each other. Talks of the marriage did not take place but failed. The failure was on account of the consensus not being arrived due to cost equations. Though the complaint and the statement narrates that the petitioner has had a sexual intercourse with the complainant, initially forcibly, but the said force cannot be seen to continue for 5 long years. Once there is allegations that whatever the sexual intercourse, that was the forcible sexual intercourse, but the sexual intercourse keep on continuing for 5 years. It cannot be possible. It beyond the imaginations, and yes, it is for 5 years. It is forcibly. The narration would clearly indicate the relationship between the petitioner and second respondent was consensual. If it is consensual, it cannot be agreed that it would become an ingredient of the rape. If it is the relationship is a consensual relationship, it cannot be alleged that it would become an ingredient of the rape under section 375 of the IPC. For it to become punishable under section 376 of the IPC. It is not the part of the rape. The police, on the basis of the aforesaid statement and investigations, have filed a charge sheet in the matter, column 78 charge sheet, which reads as follows. And in this case, this FIR has been quashed. The order is criminal petition allowed in the part charge sheet insofar as offences under section 376, so and so IPC are concerned stand quashed. This is the latest judgments of the questing. FIR has been registered, charge sheet has been filed, but this is not the genuine case, therefore it has been quashed. And another latest judgment we will discuss on, that is the Bombay High Court, recent judgments. This judgment on 29th March 2023, hardly a month, not the month, 19-20 days earlier, this judgment has been passed. by the Bombay High Court, and in which it is also the same things have been as per the prosecutix. What the statement of the prosecutix is, prosecutix means the person, the complainant. She permitted the relationship on the assurance of the marriage being solemnized, but when she asked for it, he refused. Thereafter, they started residing separately. They were living together sometimes, and there are certain marriage was promised, as the allegation is, but there are some reasons that marriage didn't take place. Therefore, started residing separately, and the relationship between them are severed. It is alleged that the applicant via internet forwarded some options messages, and there are certain allegations. And whatever the allegations, maybe the allegations anyone. The above complaint resulted in invoking offense under section. Then there is a complaint. FIR has been filed under section 376 of the IPC. Then what will happen? Prosecutix, and there is a finding that admittedly prosecutix was measured at the time when the relationship was established, both emotionally and physically. She was at the age where she is presumed to have sufficient maturity of the understanding the consequences of her act, and according to her own version, on some occasion relationship was consensual, but sometimes it was possible. From the reading of the complaint, it can be seen that the applicant's promise to marriage the prosecutix was not in the only reason for permitting the applicant to have sexual intercourse, indulgence, as according to her own version, she was in love with the applicant. She was clearly conscious of the effect of the sexual indulgence and the relationship being continued for a considerable length of the time. This is the main important, that the considerable length of the time do not give rise to the conclusion that on every occasion only on the promise of the marriage that sexual relationship was established. The couple used to meet often, and repeated sexual indulgence was out of love affair between them, and it was not necessarily preceded by the promise of the marriage on every occasion. It appears that they decided together for some point of the time, and then they separated. The only developments in statement complaint that the applicant avoided to perform the marriage. What will happen? Then this is also first. In the present case, it can be clearly seen that for prolonged period of 8 years, they were living together for long period of 8 years. Present case, it can be clearly seen that for prolonged period of 8 years, the relationship between the two continued. And it cannot be said that only because she was under misconception that he is going to marry her, she had consented for sex. The prosecutix is sufficiently of the matured age to be conscious of the relationship, both physical and mental, and merely because the relationship had now turned sour. Our main theme is failure of the living relationship. Here is the word being used, the relationship had now turned sour. It cannot be inferred that the physical relationship established with her on every occasion was against her will and without her consent, since the couple used to meet in isolations with no indication that on every occasion when the physical relationship was established, the promise of marriage was made, when she was unequivocally consented to the physical indulgence without any grievance being made till she lodged FIR in 2016. I do not think that sufficient ground exists to proceed against the applicant by charging him under section. I do not think that sufficient ground exists to proceed against the applicant by charging him under section 376 of the IPC. So this is the finding. Moreover, the prosecutix in her statement recorded under section so admit that several occasions physical relationship was established between the couple, and he was to get married to her. In the said statement, she was also stated that it was relevant to her that he was established physical relationship with some other girl, and girl was staying with her, the paying guest. From the statement prosecutix in FIR and the statement under section 165, it cannot be inferred that there was a failure to perform the marriage and promise was not fulfilled. In any case, physical relationship maintained with the prosecutix was not solely on the promise of the marriage, but since she was in the love with the applicant, she permitted him to indulge physically, and this was repeated on the several occasions according to her own version. As far as the offense is section 320 IPC is concerned, bare allegation is made to the effect that the prosecutix was assaulted without any details being furnished, and said allegation is a vague, and it could be in the postal circumstances refusal of discharge of the accused by the impugned order by exercising power available in the said court cannot be justifiably exercised, and two, merely with an observation that some time intercourse was possible, two mature persons coming together. Finding is two mature persons coming together and investing in a relationship, one cannot be blamed only because of the other complaint of the act of the some point of time when the relationship did not go well, and for what reasons need not ultimately culminate into the marriage. The wake of the impugned order dated so and so cannot be sustained. So this was again this was cast for the long-term relationship of the 8 years. Another judgment we will discuss of the Honorable Supreme Court of India, Dhruvam Mullaridhara Sonar versus State of Maharashtra. It is of the 2018. In this matter also, the proceeding was quashed. Section 482 of the criminal proceedings, said with section so and so, so and so. There are the certain act under also. The FIR has been registered in the complaint respondent at relevant point of time. Appellant was serving medical officer where complainant was working as an assistant nurse, and there was a allegations that they are living together for so long time. This is the very clear cut was made that there was a clear distinction between the rape and consensual sex. The Honorable Supreme Court defined this. There is a clear distinction between rape and consensual sex. The consensual sex cannot be termed into the rape, and allegations cannot be under section 376. FIR cannot be registered and can be quashed later on. There is a clear distinction between the rape and consensual sex. Court in such cases must very carefully examine whether complainant has actually wanted to marry victim or had malified motives and had made a false promise to this effect only to satisfy his lust, as later fell within the ambit of the creating a description. There was also a distinction between mere breach of a promise and not fulfilling the first promise. If the accused has not made promise with the sole intention to seduce prosecutors to indulge in a sexual act, such an act would not amount to rape. There might be a case where prosecutors agreed to have sexual intercourse on account of her love. This is important. There might be in a case where the prosecutors agreed to have sexual intercourse on the account of her love and passion for accused, and not solely on the ground of the misconception created by the accused, or where an accused on account of the circumstances which he could not had foresee or which were beyond his control was unable to marry, but despite having every intention to do so, such cases must be treated differently. If the complainant had any malified intention and if he had clandestine motives, it was clear case of the rape. Acknowledged consensual physical relationship between parties does not constitute an offense under section 376 of the IPC. Then, friends, I will try to elaborate what is I have tried to elaborate each and everything. What is the living relationship, and once there is a failure in the living relationship, what happened and how it can be come out, how you can go for the anticipatory bail, how you can go for the regular bail, and how you can go for the questioning and FIR. And nowadays, in the most of the cases, bail, anticipatory bail, and questioning has happened. We have recently discussed of the judgments of the 2023 of the Bombay High Court and another Kerala High Court and Honorable Supreme Court. So, dear friends, probably my time is over. It was session for the 1 hour, but at least the topic is a very debatable topic nowadays, and it takes some more time you can discuss upon. But please switch on your cameras. I want to see some beautiful faces, and whatever my learner friends are joining my session, I'm very thankful and obliged to all of you that you are giving your very precious time. Krishnada is the very looking in the happy mode and always should be God blessed to be always be happy. So please switch on your cameras, and if there is a now we are in the question and answer sessions, and any of our friends wants to ask any questions, please, questions are always welcome. Please switch on your all switch on your cameras, please. So that we can see the faces. Yes, my friends. Want to ask any questions? Deepak ji, you are most welcome.
Good afternoon, sir.
Good afternoon. Good afternoon. Yes, there is a
I have only one question which is related to this. Sometimes when 376 is alleged, right? So
Yes, yes.
120B also on the friends and non-relatives are also with the 376. So how to safeguard if 120B is also
120B is the common intention. If it is a
because
common intention of
sometimes
the
they
person,
show it is a conspiracy by the friends and all that, female partner, female friends and all that. So how to safeguard them also?
yes, yes. Once there is a once 120B is also inserted, then of course the whatever the judgment we have discussed, that of course we will move the anticipatory bail first, and once we will go on to the anticipatory bail, there is no issue at all. And in the most of the cases nowadays, the honorable courts, even the session courts, is granting anticipatory bail. So once you grant anticipatory bail,
In that case, we have to move the application in session court first, and if the session court is denied that, then we can approach to the high
yes,
court.
only
Right?
the session court has a power. Below the session court doesn't have a power to grant anticipatory bail or regular bail.
Okay, sir.
Normally, anticipatory bail powers are always vested with the session court, high court, and there no court below the session court has a power to grant anticipatory bail. And in other cases, even the metropolitan magistrate also has a power to grant the bail, like as a 420 cases or another 380 cases. But in this, once the charge of the rape under section 376, the metropolitan magistrate doesn't have a power, even in the regular bail also. Even in the cases of the regular bail, you have to approach the session court only.
Right, sir.
Please.
Okay, thank you, sir.
Thank you. Thank you. Krishna da?
जी जी
आप बताइए क्या आपको कुछ डाउट रहा हो?
First of all, I would like to thank you, sir.
Thank you. Thank you.
Very
Thank
good
you.
session.
Thanks to all of you for joining us. And certainly, it would be interactive once you will ask certain questions, certain queries, and you will discuss something. Because it is an online session and it is one-way communication that we are communicating only in the time being. But this is the time now we can communicate in the both ways.
Right. You're right.
Otherwise, in the physical sessions, we can directly ask questions, and people are already used to come forward and ask questions in the meanwhile session is going on. But in the online process, there are the certain people are joined once they are asking the questions, then chaos will be created.
Probably your session was so good. It was very easy to understand for anyone.
Please. Thank you, sir. Thanks a lot. So, my friends, yes, Saurabh. Saurabh is here.
Good afternoon, sir.
Good afternoon. How are you? Yes. You want to ask certain questions, or everything is clear?
Everything is clear, sir. Everything was well elaborated by you, sir. Thank you so much for enlightening us on this topic, sir.
Thank you.
And we got to know the certain judgments of the Honorable High Courts in this regard, which will be helpful for us.
Yes. Certainly, once you are taking the session, you will try to take the latest judgments of the Honorable High Court, Supreme Court, and different high courts, so that we can keep being updated. And this is the one of the platform where we can be updated. And any one of our friends wants to take the sessions on any subject matters, and they all are the most welcomes, and they can prepare and they can utilize our platform. And certainly it will grow further. Certainly, once you will share something, certainly you will also get knowledge of that particular subject, because no one can be the expert of anything.
Absolutely, sir. And it is very helpful for the young lawyers, sir.
Yes. I always invite the young lawyers that yes, young lawyers should also join. And
Yes, you are still young, dear friend.
You will remain young.
Thank you so much, sir.
Thank you, friends, to all of you joining us.
Sir.
Thank you.
Namaskar. Now we can leave the session.